All right, I'm here to give you a case law update. It's meant to take about half an hour. So what I've thought is, I've looked back over this year, thought particular cases which I think are particular relevance to local authorities in the development management or development control area of law. There have, despite the lockdown, been a huge number of cases before the courts. But I hope that these, I think there are some 9 cases in the time available. I hope they'll be of relevance and assistance. And the content page, which you should now be able to see, I thought I'd begin right at the beginning of a planning application by looking at that process which arises where there's a question as to whether development constitutes, requires an environmental impact assessment. Then I'd go on to look at section 38.6. We get out our development plans and consider whether the particular application accords with the development plan as a whole. Then consider paragraph 11 of the NPPF and the policy guidance there as to how the presumption in favour of sustainable development is to be applied. Then consider heritage considerations. We've heard about the how often these matters come up, and I focus on 2 particular issues. What is a listed building, and also the contribution of buildings or particular parts of a building to a conservation area. I then looked at another old chestnut, openness in the green belt. What does it mean and its interrelationship with visual matters? Next, when is a consideration material in planning terms? We've dealt with the penultimate bullet point, the use of planning conditions. That's the DB symmetry case. And then I have a case also, finally, on officer report writing, which I think picks up, all of these things pick up some of the topics that we've heard from others already today. Now, in terms of screening, the important case I wanted to draw to your attention was the case of Swire, Queen on the application of Swire against the Secretary of State. This year, it was a High Court decision, and the Secretary of State had issued a screening direction saying, no, I don't think an environmental impact assessment is required in this case. And the background was that this was a site where it was going to be housing. It had previously in the past been, and still was, a licensed site for the disposal of animal carcasses following the ghastly BSE issue that we had some years ago. And the importance of this case is as to whether, when deciding whether an environmental impact assessment is required, the decision maker, be it the local planning authority or the Secretary of State, can take into account the remedial or mitigation measures which the applicant is proposing. So we have to consider, is the proposed development likely to have significant effects on the environment? In deciding whether it's likely to have significant effects on the environment, can we take into account what is proposed by way of remediation or mitigation measures? And it was held, yes, you can take into account the proposed remediation or mitigation measures. And pausing there, that there's an important difference, therefore, between the EIA situation, you can take into account remediation measures when deciding whether, at the screening stage, whether an environmental impact assessment is required. And that contrasts with the position under the habitats regulations, also the latest ones in 2017, as to whether an appropriate assessment is required. And you recall that an appropriate assessment is required when the development is likely adversely to affect the integrity of a European site or a European offshore marine site. So, and in the case of habitat regulations, you cannot take into account, when deciding whether an appropriate assessment should be undertaken, you cannot take into account remediation or mitigation measures. So it's an important issue. difficult for local authorities. Something comes in and it has both EIA issues and habitat regulations, and one has to compartmentalise them and look at them separately. But the court went on to say that when you're considering, in the context of an EIA, whether the proposed remediation or mitigation measures, before you can take them into account and say, oh, look, those mitigation measures will be put in place, you must have sufficient evidence of the potential adverse impacts and the availability and effectiveness of the proposed remedial measures. You can't say, well, something can be sorted out in due course. On the facts in that case, there had been a lack of expert evidence and risk assessment as to the nature of any remaining BSE-related contamination at the site and any hazards it might present to human health. The measures which might be required to remediate any such contamination and hazards had not been identified. That's at Secretary of State level, so it's not a criticism of local authority, it's Secretary of State level. It's an important case. You must have sufficient evidence. Don't just say, oh yes, we can take it, something can be sorted out to remediate this. What is going to be done and what is the impact of that, and how likely is it that it can succeed? So I draw attention to Swire right at the outset when you get a planning application in. Just as footnotes, I refer to the fact that obviously for EIA we're under the 2017 regulations. They derive from the 2011 and 2014 EU directives. Often asked, what's the effect of Brexit? Well, technically there's no change because EU law becomes UK law for the time being. But the Prime Minister has announced that there will be a review of the EIA, appropriate assessment, strategic environmental assessment process in due course to end what the Prime Minister calls the newt counting delays. Where that will go, I'm not sure. It may depend on, obviously it's going to depend very much on political considerations. It may even depend on Chief of Staff and backbench views. So that may or may not happen. Certainly there seems to be an appetite in certain quarters for there to be a change, but it's not clear to what extent that will occur. I also draw attention to the fact that the Office for Environmental Protection, OEP, will be the domestic independent watchdog responsible for taking action in relation to breaches of environmental law. That's as proposed in the Environment Bill, which is going through Parliament at the moment. And finally, I draw to attention for decision makers, the NPPG, Section 4, Environmental Impact Assessment, gives copious amounts of advice to local authorities. Then I turn to Section 38.6, whether the application accords with the development plan as a whole. And I draw to your attention the Corbett case against Cornwall Council. And that held that a breach of a single policy does not necessarily mean that the application does not accord with the development plan as a whole. Well, that sounds fairly satisfactory and intelligible. What was that case concerned with? Well, it was concerned with an extension of an existing caravan site, obviously very much something one would expect in Cornwall. But what is more interesting, perhaps, is that there was a conflict with that extension with policy, and the policy in the local plan said developments will not be permitted that would cause harm to what was an area of great landscape value. And in that case, the extension was going to cause some harm to the area of great landscape value. But also in the local plan, there were policies encouraging development for tourism. And having the local authority looked at the plan as a whole, and they said, well, the application does accord with the development plan as a whole. Court said, yes, you're perfectly entitled as a matter of fact and degree to conclude thus. So even though there would be some harm, overall, because of the clear policy encouraging development for tourism, which is obviously very important to Cornwall, one could say, well, it does accord with the development plan as a whole. Some harm, but overall, it accords with the development plan as a whole. And I think that's important. Often one does see in proofs of evidence from both sides to a planning appeal, there's a breach of this policy, therefore it doesn't accord with the development plan as a whole. No, it needs a more sophisticated approach. Anyway, I move on from that to another area, which is about the NPPF paragraph 11, the presumption favour of sustainable development and the relevance of development plan policies when you're applying that presumption. As you all know, and one has to set it out on the slide because it's rather a mouthful otherwise, and no one can ever remember precisely what it says, but where there are no relevant development plan policies, or the policies which are most important for the determining the application are out of date, grant permission unless, first little one, the application of policies in this framework that protect areas or assets of particular importance provides a clear reason for refusing the development proposed, or, little two, any adverse impacts of doing so would significantly and demonstrably outweigh the benefits when assessed against the policies in this framework taken as a whole. And you can see in little Roman 1 and little Roman 2 the reference to policies in this framework, in the first line and the last line. And footnote 6, and you'll see that footnote 6 is reference, I put it in red for ease of seeing it, in little Roman 1. Footnote 6, which is just in little Roman 1, says that the policies referred to are those in this framework, brackets, rather than those in development plans. So it simply says that when you're looking at little Roman 1, the application of policies in this framework that protect areas of assets or assets of particular importance, do they provide a clear reason for refusing the development proposed? And so the footnote is saying you simply look at the policies in the framework, not at any development plan policies. The question which arose in the case to which I'm coming in just a moment was, what about little Roman 2? When it refers to the policies in this framework, does that mean one also ignores leaves out of account the development plan policies in this exercise? Well, Gladman is the name of the case, Gladman Developments against Secretary of State and Corby Borough Council, and also Gladman against Uttlesford District Council. Conjoined cases. I set out the issue, does NPPF paragraph 11d2 require the tilted balance to be struck without taking into account policies of the development plan, leaving those matters to be weighed separately under section 38.6 of the 2004 Act? And the court's answer was a resounding no. The exclusion by footnote 6 of policies in development plans in respect of the application of paragraph 11d1 was clearly intended to reverse, said the court, the observation of Lords Carnwath and Gill in the Hopkin Holmes case, where they had said that one shouldn't have regard to development plans in on the particular provisions. And the court went on to say that given that footnote 6 refers to paragraph 11d1 alone, not to 11d2 as well, the decision of the court that policies in development plans are not excluded from the application paragraph 11d2, well, that hardly seems surprising. But it's important because it's all very well to say we have to go through the tests. It's not, one has to look very carefully at all the little footnotes and work out in this NPPF exactly what the policy is saying and what the requirements are. So there's a difference between paragraph 11d1 and 11d2 in terms of whether you have regard to the development plans when considering those respective sub-paragraphs. Moving on then to heritage considerations, what is a listed building? I think this morning Christian was talking about how heritage comes up a lot of the time, and that's absolutely right. It's become can be a complex area, but also it's a very important area, and it rightly has its place in the NPPF. But we get particular issues which need to be considered. What is a listed building? You might think that's fairly fundamental. Of course it is. And it's a little bit surprising it hasn't been considered for the last 30 years or so. Section 1.5 of the 1990 Act, and I always encourage clients to start off with the statutory provisions, then you'll have a better feel sometimes for how the policy fits into it. Start with the legislation. In this Act, listed building means a building which is for the time being included in a list compiled or approved by the Secretary of State. And for the purposes of this Act, A, any object or structure fixed to the building, and B, any object or structure within the curtilage of the building, which, although not fixed to the building, forms part of the land and has done so since before July the 1st, 1948, shall, subject to subsection 5AA, be treated as part of the building. So it's the building, an object or structure fixed to the building, or an object or structure within the curtilage of the building, which has formed part of the land since before July the 1st, 1948, when the Town and Country Planning Act, that Act came into force. Now, the decision of Dill, and Christian referred earlier to the pier surmounted by an urn. I'll show you a picture of it in a minute. There were two 18th century limestone piers, each of which was surmounted by a lead urn or finial. They'd been removed and sold. Listed building enforcement action was taken for their reinstatement. The piers and urns were separately listed from the house, but were they buildings? And there on the right-hand side, we have a picture of one of them. You can see the pier and then the lead finial on top. It was held it was not enough that this object, this structure, if we can call it a neutral term, was listed. It must be a building too. And that issue could be raised on an enforcement notice of appeal. We didn't have to judicially review the Secretary of State back in 1980s when he'd listed this. You could raise this issue on an enforcement notice of appeal. Thirdly, the test for whether it is a building, but we're all looking at it thinking, is this a building? You apply the well-known Skerritt's tests that we apply for planning cases, general planning cases. You look at its size, its permanence, and the degree of physical attachment to the ground. In this case, the matter was remitted because the court said that that would have to be redetermined, hadn't been considered according to those tests. Happily for the owner, the local authority, I think, decided not to take any further action. Unhappily for the lawyers and planners who might like to have known whether that is a building, that hasn't got a final determination. But clearly it's a matter of fact and degree applying those three issues, and obviously depending on the particular facts, and we don't have all the facts before us. Anyway, so Dill is an important case on reminding us that it's not enough just to be listed, it must be a building too. They also said that a statue or other ornamental object which is neither physically attached to the land nor directly related to the design of the relevant listed building and its setting cannot be treated as a curtilage structure. So it's an important case there for what is a curtilage structure. Is a statue or object, can that be a curtilage structure? It depends on whether it's physically attached, clearly for section 1.5, and also section 1 subsection 5, and also whether it's directly related to the design of the relevant listed building. It was also held that it's not sufficient that an object might be of special interest in itself. It must be the building which has special architectural or historic interest. So there's quite a lot in that case, important case, when one comes to listed buildings. Clearly, it's not going to be in every case that you get this sort of structure to consider. Coming on to more general heritage considerations, obviously there's a lot about listed buildings, but also, of course, conservation areas are designated heritage assets. And there's a case this year in the High Court, Spitfire Bespoke Homes. For conservation areas, again, we start with the statute. Section 72 of the 1990 Act says that special attention should be paid by the decision maker to the desirability of preserving or enhancing the character or appearance of that area. And it was held that when discharging that duty, the decision maker is not constrained to look only at the impact of the existing buildings taken as a whole on the conservation area. One can take account of any positive contribution made by individual components if she or he considers that that contribution to be of significance and relevance to the overall assessment. And what this basically means, you look at existing building, let's say you have a particular building, you say, does this make a contribution to the conservation area? You might say, well, actually, looking at it as a whole, yes, one elevation makes a positive contribution, but as a whole, it really doesn't. It doesn't overall because it's been rather knocked about over the years. Judged as a whole, I don't think it does make a positive contribution. They said, yes, that's fine, but if you think that one aspect of that building or one building out of a number of buildings does make a positive contribution, you think it's important, then you can give weight to that and regard it as significant. So it's simply saying, don't just say, well, look, looked at as a whole, that building, or looked at buildings as a whole, it's neutral overall. There's so many detracting points. If something is a particularly positive, you can say, no, but notwithstanding that, it is important that we seek to preserve or enhance the character or appearance of the area by maintaining that aspect or not granting permission. Obviously, one does a comparison with what is going to replace it, if permitted. I then move on to openness in the green belt, and Samuel Smith Old Brewery, Sam Smith, has been a litigant for many years on a wide range of issues. And in this case, again against North Yorkshire County Council, there was a 6-hectare quarry extension proposed. It was in the green belt. The issue was whether the proposed mineral extraction would preserve the openness of the green belt or otherwise conflict with the purposes of including the land within the green belt, for example, to prevent urban sprawl. Now, Lord Carnwath in the Supreme Court held that the NPPF paragraph 90, which deals with what's appropriate development in the green belt, does not expressly refer to visual impact as a necessary part of the analysis, nor in my view is it made so by implication. The matters relevant to openness in any particular case are a matter of planning judgment, not law. Such relatively limited visual impact which the development would have in that case fell far short of being so obviously material a factor that failure to address it expressly was an error of law. And really this case brings us full circle back to what I always understood the position to be back from the 1980s certainly, that openness generally means the absence of development. It doesn't automatically import visual considerations. Clearly, it's not to say that one can't have regard to visual impact, and it may in a particular case be very important too, because it's not just a question of openness, it's also a significant visual impact. But preserving the openness can be preserved by not building. It doesn't necessarily import issues such as what is the visual impact, does that affect the openness? So that's an important case. It's summarised, goes through all the case law, comes back to what I would regard as being the conventional approach to the meaning of openness in the green belt. They stress, of course, it's always a matter of fact and degree, and the courts don't like to interfere if at all possible. I then come to this: when is a consideration material? Well, there's been a recent case, and this is important because, as we all know, in climate change, wind turbines are clearly here to stay, and existing ones will come up for renewal in due course. This case came before the Supreme Court in a case called Right and Resilient Wind Energy. The Supreme Court endorsed the Newbery criteria, the well-known Newbery criteria, regarding the imposition of planning conditions, i.e. to be capable of being a material consideration, the consideration must be 1, for a planning purpose, 2, fairly and reasonably related to the permitted development, and 3, not be so unreasonable that no reasonable planning authority could have had regard to it. Now, it was held in that case it was unlawful for the local authority to take into account a community benefit fund, which is to be set up and to be derived from 4% of, it was a single wind turbine's turnover. It was held it did not comply, this community benefit fund proposal did not comply with 1 of the Newbery criteria, i.e. it was not for a planning purpose. The ulterior purpose was of general benefits for the community. Nor did it comply with 2. It wasn't fairly and reasonably related to the permitted development. It didn't affect the use of the land. It was a general inducement to the local authority to grant permission. And they stress that one cannot buy or sell planning permissions. This has been a theme which comes to the surface from time to time. I can go back to the case of City of Bradford in 1986-87, Old Justice Lloyd stressing this, and then you can see the whole theme coming through cases such as Tesco Stores Limited and Secretary of State for Environment in 1995, all the way on into the cases such as Sainsbury's and Wolverhampton about compulsory purchase. The courts are very, very concerned to ensure that one cannot buy or sell a planning permission. So we need to look great care. So often in planning applications it's said, oh look, the new homes bonus, it's going to take that into account, lots of money. The guidance, one looks carefully at it, says no, only if you know what the money is going to be spent on locally and it's related to the particular development. Otherwise it's irrelevant. SIL can be taken into account because the SIL regulations expressly permit the Town and Country Planning Act Section 70 expressly permits it to be taken into account as a local finance consideration. But it's very important to be scrupulous on this and ensure that only relevant matters, material matters, are taken into consideration. I'll tell you about a recent case, which I haven't been involved in, but it's more significant than that. And that is the use of planning conditions, and in particular, in this particular case called DB Symmetry Limited against Swindon Borough Council and the Secretary of State, the local authority claimed that the effect of their condition was to require my client, DB Symmetry Limited, to dedicate certain access roads to a major development as public highway. The condition in question, I've set it out on the screen. The proposed access roads, including turning spaces and all other areas that serve a necessary highway purpose, shall be constructed in such a manner as to ensure that each unit is served by fully functional highway, the hard surfaces of which are constructed to at least base course level prior to occupation and bringing into use. One issue was whether this condition required the developer to dedicate the roads as public highways, or whether it merely sought to regulate the physical attributes of the roads, to the standards of construction and the timing by which they had to be constructed to a certain standard. The Court of Appeal held that both interpretations were realistic, both the council's and my client's. Indeed, the council's interpretation, namely that it did require the dedication of the roads as public highways, was the more natural interpretation. But the court held that the first interpretation would mean that the condition was unlawful, because they said, in reliance on long-standing case law, in particular Hall and Shoreham by the Sea Urban District Council back in 1963, had held that one could not require by planning condition, that access roads be dedicated to the public. But as they said, the first interpretation would mean, or that interpretation would mean, that the condition was unlawful and the whole permission would fall. Given that situation, the court would apply what is known in the public law field as the validation principle, or the principle of validity, and adopt the second interpretation. So it's an important case for that principle, that if a condition has two realistic meanings, then the court will adopt the meaning which renders the condition lawful. There was also a challenge to the decision in Hall and Shoreham, where it had been held, as I said, that it was Wednesbury unreasonable for a council to impose a planning condition requiring the developer to give a right of passage without compensation over a road it was required to construct on its land. The council, before the Court of Appeal, argued that Hall turned on its own facts and did not establish any wider principle. The Court of Appeal disagreed and held that Hall remains good law. And I should say that, just before we break out into your other rooms, that Hall is consistent with the understanding the law which has informed government policy continuously for 69 years, from Circular 58 of 1951 to the present day PPG or NPPG advice, which is to be found in the use of planning conditions section, which is section 21A, paragraph 005, if you want to look it up. Anyway, I think that's, I will leave it there, because I think we're all ready now to go into our separate rooms. But it's an important case, and Swindon are presently applying to the Supreme Court for permission to appeal. So there may or may not be further progress on this case. And then that just brings me to a case about officer report writing. This case called Adverse Dorset Council. The case concerned major development in the AONB. It was close to a conservation area and a listed building, and it was held that the report committee did not assess the significance of the conservation area, nor the extent of the impact of the proposed development on that significance in any coherent way, nor assess the extent of harm to the setting of a listed building, and if concluded less than substantial harm, because it didn't weigh that harm against public benefits. Now, I refer to it for this reason. This is my last slide. It said this: officers' reports must meet a basic level of coherence. No detailed legal exposition is required. In most instances, any such approach will be best avoided. But if, as in this case, a relevant policy requires a particular matter to be addressed systematically, and pausing there, as Christian was saying earlier, that's very much with listed buildings, conservation areas, going through the NPPF designated asset, less than substantial harm, what's its effective significance, etc. So that it requires a systematic approach. Then the report should include some narrative as to what the system is and how it applies to the case in hand. None of this is sophisticated. In this case, the court said, the report needed to do no more than identify the conclusion as to the extent of the impact of the adverse farm development and the reasons for that. Explain that that harm needed to be assessed against the public benefits of the proposed developments, and then either state a reasoned conclusion on the matter or leave councillors to undertake the assessment for themselves. And that last bit is very much, do you think the benefits outweigh the harm? Well, that you can decide to leave that to members to consider. But I think this is the vast majority of reports that I've seen over many years now are exemplary, very, very good indeed. There are some howlers along the way, and then there are those which are just about all right. I think Christian gave some useful advice this morning about thinking, when you're writing a report, where could this end up? It doesn't have to be overly sophisticated. It's important that it simply addresses the points. It doesn't have to be lengthy, but demonstrate that one's aware of what the policies are and apply them, reach a conclusion. Simple, common sense, but I thought this case was quite a good warning that as the perils, if one doesn't, particularly when one's dealing with heritage, take care. Anyway, those are my chosen 9 cases, which I hope will be of some assistance, and they summarise all that's the main issues that have arisen this year in the development control field. And thank you very much indeed for your attendance. I think we're going to be taken back into the original waiting area for some final words from Richard. Thank you.